Thank you, David. We met in Sweden in late September, early October 2020.
It was in October, I think.
2023. And,
yeah.
You know, I saw you give a 2.5-hour presentation on this topic.
It was the first one I did.
Yeah, I went up to you after and I said, do you want to do a film on this?
Yeah.
And it's quite a complicated topic, huh?
It is so big in terms of the implications, and it takes some work for people to enter into it, a full understanding of it. But there are features of it that are really quite simple. Once you're able to wrap your brain around it, they're quite simple concepts, really.
Yeah. So at its most simplest, how would you describe it in a sentence?
I think it is about severing direct ownership rights to securities used as and that are then being used as collateral without the knowledge or agreement of the public, and then they are very vulnerable to insolvency. And it seems, given the deliberateness and persistence of the execution of this, that it's by design. This did not happen accidentally, so it seems to be pointing toward taking all of this in a kind of very large-scale event of some kind. That's what I'm illustrating.
Yeah, so it seems you've kind of uncovered like a really big story. Its implications are so big that it's hard for the average person to get their head around.
Yeah.
And it's kind of interwoven with a lot of things we do know, like the financial sector is out of control, and the derivatives market has exploded beyond all measure. And the connection with that the use of the underlying collateral of everyone's stocks and bonds has led to this spike in the explosion of the financial markets.
Yeah.
Why do you think no one's pointed that out until now?
I don't know. I mean, there are, we were talking earlier today, there are a few things here that I am pointing out that no one has ever explained or focused on before, that's just been there to expose. So that the change in the Uniform Commercial Code legalizing the use of this pooled collateral, 1994, that was coincident with the dramatic escalation in derivative instruments outstanding. So it was really just getting underway in the 90s, the growth in derivative contracts. So right while this was being implemented, by 2001 or so, they were over $100 trillion, which was about twice global GDP. By 2007, it had gone to 700 trillion, so it had gone up essentially sevenfold in 5 or 6 years. Just phenomenal growth, and no one would really question, how is that even possible? What is backing that?
I think a lot of financial people heard about that.
A lot of discussion of the use and reuse of collateral. The collateral chains, it's called hypothecation, rehypothecation, and that this was being done many times over, that collateral was extended and then reused by the party that had received that collateral. But no one ever asked the question, what is the source of the collateral that is being extended? Where is that coming from? Never discussed.
It's kind of a theme in propaganda I've seen. It's like you tell the truth, but then leave out the critical information of like, oh, there's all this collateral, but what was it? It was people's assets. Huh?
What is enabling this, and why didn't it happen before? Why is it happening now? Why didn't it happen before? And this is the answer to that. The other thing that has never been exposed is that DTC is a creation of the CIA. And it's quite clear this is the central depository for all this collateral that is being used this way. It's the clearing corporation, and its members use this collateral. And how do we know it was a CIA operation? Well, the guy that was tasked with forming it was a career CIA operative by his own admission. And then
what's his name?
Robert Denser.
Robert Denser.
Yeah, and so you can find interviews with him where he doesn't hide that he had no background whatsoever in finance or banking.
Yeah.
But he had a long career in the CIA. And then the other thing that points to this is...
But what do you think that means, like that he was working for the CIA?
Well, I think there is a massive global geopolitical purpose behind this. This is essentially part of a global war strategy, hybrid war strategy, long-term planning, beginning certainly in the 60s, because the other smoking gun is the paperwork, the so-called paperwork crisis that people still point to as a justification for what's called the indirect holding system. And this is another thing that no one has really ever exposed before.
When I researched it, you just hear all these kind of conventional
platitudes about it. It isn't examined. The CIA involvement is not examined or exposed, but that this paperwork crisis was
necessitated dematerialization. Right?
Yeah, which was used as justification, was not a real crisis. It was a fabricated crisis. And to go through the timeline, what they did was they closed the New York Stock Exchange just on Wednesdays
for 6 months, right?
For 6 months,
This
from
in
June to
1966?
December.
1966 or?
No, 1968.
68. Okay.
And the paperwork crisis began 6 days after Robert Kennedy was assassinated. And now I mention that because Robert Denser mentions in his memoirs that his interest shifted back to the United States. He had been, just prior to this, with U.S. aid in Latin America, which is a CIA organization.
And just for people to know, the CIA's kind of been the plaything of big Wall Street banks from its inception with Donovan, who was a big Wall Street lawyer. So it's kind of indicative that its actions on behalf of larger financial houses, huh?
Yes.
Yeah.
Well, I think most people did not know that, but we should be catching on by now.
Yeah.
So he mentions in his memoirs that his interests shifted back to the U.S. following the assassinations. That his interest shifted back to the U.S. following the assassinations.
Yeah.
And the paperwork crisis began 6 days after Robert Kennedy was assassinated. And they closing on Wednesdays every week, they paid the brokers special bonuses, so they were happy. They didn't have a problem with it. And then magically, there was no crisis at the end of the year. Now, why? Were securities dematerialized? No. There continued to be paper trading for another 5 years. 5 years. And more. At least 5 years, because DTC was not formed until 1973, 5 years later. How did the markets function for 5 years with paper certificates if it couldn't be done? Then, by most admissions, there was no significant dematerialization until the 1980s. And I remember that. I mean, this is a coincidence, but one of the firms I went into when I was, virtually a child in my first year in New York was Depository Trust Corp, working with the engineers when they were beginning to set up, or at least extending, the network, communications network in the U.S. for the network infrastructure for this. So that was 1983 so it was still early days at that point.
Well, let's get on to what we've been doing recently here. So your book came out last summer, and probably over 1 million people have read it or become quite alarmed by what you've discovered there. And then we met, and then some people picked up all this stuff, and state legislators have been flooring some bills to correct these 94 to 98 UCC alterations that give priority to essentially the too big to fail banks, to have priority ahead of the retail investor or institutional investor in securities, in the event of a meltdown of the intermediary, essentially the DTCC.
Or somewhere in the system, but intermediary is kind of a global term for all the entities in the infrastructure.
Yeah. So essentially, the way it's written, it looks like it gives the too big to fail banks a sort of priority to seize everyone's assets in the event of a meltdown, and it changed the legal relationship to say that the average stockholder has a contractual claim through a securities entitlement, and the too big to fail bank is a secured creditor when they enter in a derivative. Let's talk this.
Yeah. Well, the code, the UCC specifically in Article 8 uses language about the priority of entitlement holders versus the secured creditor of the financial intermediary. So it's not the secured creditor of the client, of the entitlement holder. It's the secured creditor of the intermediary. That is the issue. And it appears, it does mention derivatives, it does mention how they're used, it's just this relationship in terms of priority. You have to look elsewhere to understand how it's being used, what the purpose is. But this dynamic, this is irrefutable because it's in the language, that is the issue it turns on, is priority between the entitlement holders and the secured creditors of the intermediary. So the section starts out by saying that the entitlement holders have priority, and that's what was exposed to sell the amendment. There is an accompanying statement with there's a website about the 1994 amendment, and you can see this statement, which was used to explain the amendment, and it is explained in a highly misleading way, because it says that the entitlement holders have priority, and that was the purpose, but it does not mention the exception beneath that, which is easily seen if you look at the code. And
this is this theme we're seeing with all these exceptions. They'll say you have property rights except when someone else takes it from you.
Yes. And so the exception is that if the secured creditor of the intermediary has control, the secured creditor has priority. Now, control is a concept in bankruptcy. Bankruptcy attorneys will talk about perfection of control. Have you perfected control? That just means that you have the property and you can sell it. You have sufficient control over it that you can sell it. And in an indirect holding system, within the infrastructure, the intermediaries always have control because it's in their system. So when you had paper certificates, they absolutely did not have control. That was the reason to dematerialize them. When you had a paper certificate, you had a bright line as to when they had control. So you actually had to sign it over to them. But clearly, once they were dematerialized, they started using these pools of securities, even though it wasn't legal for them to do it. Between, they were doing it in the 80s. They were starting to do that. Yeah. And then we have this statement from John S. Rogers, who was the drafter of the amendment. He is the guy that wrote it. He wrote it. And a couple of years after the amendment was introduced, he wrote an extensive document explaining the reasons for it, and that what they were doing was catching up with how the system actually operated. So they were really making legal what they were already doing. And secondly, it is mentioned that they needed to do this to prepare for the event of large-scale insolvency in the financial system. So these are irrefutable statements. This is the guy who wrote the amendment.
So just to clarify, so Wall Street and the big financial markets and the two big default banks since the 80s have basically wholesale been using everyone's stocks and bonds, every financial security, and encumbering it as collateral in the derivatives trades. And then in the 90s, it was legalized in the UCC code in all the 50 states. Yeah. From probably 94 to 98, right?
The last ones were a little after 2000. So it took them a while to get it done comprehensively in the U.S.
And then we saw the derivatives explode from 2000.
Yes.
From 100 trillion to 700 trillion to maybe 2 quadrillion now or more.
Those are the estimates, which would put it at about 20 times global GDP. So, at 100 trillion, it was 2 times. By 2007, it was about 10 times, and now it's maybe 20 times. So this is, so I would say they have worked at making sure they are using all of it. And you can look at there's a Bank for International Settlements document that I include in the book with this chart showing the flow of the collateral from the collateral givers to the collateral takers. Yeah. And there are statements in that document about their objective to utilize all collateral. And it was really done by regulatory fiat. There was actually no pressure in the system for the need for collateral, but they created the imperative for collateral with central clearing of the derivatives and the relentless growth in the scale of these derivative contracts that are centrally cleared. And so now this document is from 2014, so it was already well advanced 10 years ago. Yeah. And in this document is discussed the need for what is called collateral transformation, this means not just using government bonds, but all securities, including equities. And what they mean by transformation is that there would be yet another contract to swap the equities for government bonds. synthetically, essentially. It's a contract. So what they can do is encumber a pool of equities, and in the contract, so now those equities are encumbered as collateral, and they make a swap contract to say, all right, now you have government bonds that you can post as collateral. But all of that then ends up being encumbered in the derivatives complex as well with the central clearing counterparties. So we know that equities are encumbered through that. Also, the chart that I included in the book shows specifically equity trading desks being a source of the collateral that is flowing to the central clearing counterparties as the collateral takers. So,
so in plain English, what does that mean?
Well, the objective is to utilize all securities.
Everyone's assets.
Yes, yes, and especially in a financial crisis, to make it possible. So they have automated collateral management information systems that, and it's discussed in this document, which is 10 years old, that these will operate, particularly in a crisis, automatically to sweep more collateral to the central clearing counterparties from all these sources, custodians, trading desks, and then there is a more recent document which came out in early December this past year, 2023, so it's quite fresh, talking about a collateral spiral.
A death loop?
Something like a death loop, a margin spiral, where as price levels fall, it requires more collateral, which puts more pressure on entities to sell, which drives prices lower, which requires more collateral. So that this demand for collateral can help to accelerate the collapse. And so this document explains the structure of this. There's something called initial margin. Initial margin has always been the normal way that margin is posted. Margin is the collateral that's put up when one enters into a contract.
Yeah.
And a derivative is just a contract on the behavior. It's not a real thing, but it describes the behavior of something else. And it can be used to take real things that are posted as the collateral under the contract. So why is the collateral posted? It's like a brokerage margin account, where you've bought stocks, and if the stocks fall in value and you're getting close to your equity in the account is falling, you have to post more margin in the account or you're stopped out. Your positions will be sold out and the brokerage firm, takes the value of your account basically, or gives you the residual. The same thing happens with a derivatives contract. You have to post margin, and if the contract moves against you, you have to post more margin and more margin.
So are these contracts written to sweep the assets in a continuous way?
That's the way it would work, is they're saying the posting of additional margin is automated. So
your take on this is that it would facilitate a sort of great taking or great sweeping?
Yes. Well, there's another step. The initial margin has always been cash and high quality government bonds. So not junk debt, it's meant to be really solid. So that's the way things operate normally. But this Bank for International Settlements is very illuminating in an important way. And again, this is recent, just December, that there is also a collateral fund. And they have the line in here that the purpose of the collateral fund is to mutualize losses. Mutualize losses.
What does that mean?
Well, I think what that means, and it also explains that the collateral fund uses all kinds of securities as collateral. So it goes beyond cash and government bonds to everything else. So this is the piece that will also utilize equities, lower quality bonds, everything they can get their hands on will go into the collateral fund, and it mutualizes losses in the sense that if there is a systemic collapse, the losses will be borne by the pools of these entitlements in these assets.
Which
and
is DTCC and Euroclear.
They're the DTCC pools. It's Euroclear and Clearstream in Europe, and we know from the Federal Reserve response to the EU in 2006 that that investors are always vulnerable to the shortfall in these pools after the secured creditors take securities out of those pools. So we know this for a fact. It's explained by the the legal staff of the New York Federal Reserve. So that is where the mutualization of the losses occurs, is through the pools and through this collateral fund portion of the automation of the sweeping of the collateral.
So is the automation at DTCC and Euroclear, or where?
Well, the collateral, in 2014, the way this is discussed is that there were different entities working on these collateral management information systems, or collateral management systems. I would expect that is a DTC function, other clearing entities in Europe.
So could you describe what we've been doing here in South Dakota and Tennessee?
We met in Sweden in October, and we were thinking about, okay, how should we start this? And the idea was to chronicle to go on with exposition about the Great Taking, but to expose what could be done about it as a kind of ambition. So the first thing we thought about doing was going to see G. Edward Griffin about that, because he's one of the people who actually talked about it, at the end of The Creature from Jekyll Island. So he was very gracious and agreed to meet with us at his mountain retreat up in Northern California. And we met in LA and had a beautiful drive up through the mountains.
Yeah.
And Ed Griffin's place is in a spectacular location, about 40 minutes inland from the coast, but with a view of the Pacific from up in the mountains, and quite a climb up there. And we had basically 2 days with him. So tremendous experience. And I think, one of the things that he said that really was very significant to me was that property seems to be very important to humans, and it's deep in the species, and it's so deep in the species that it's in other species. You can see that animals and birds need to have a place, and it is associated with being able to reproduce, to have the stability to be able to settle and reproduce. And that is why it is important to us. And if you dispossess people of their property, you make them vulnerable to such an extent that they really can't have families. Or it's difficult to do so. Not that it won't happen, but you're going to cut down on it a lot. So it would be a component of depopulation, is to dispossess people of their property and make them so vulnerable that they can't have families.
Yeah.
And we see it happening.
So since your book has come out, a lot of people have been alarmed and alerting their legislators
Yes.
in different states, and there's been calls to reform the UCC code and revert it back before the 90s revision. And we went to South Dakota where the first bill was floored.
Yeah.
And the bank lobby kind of got up and didn't really address the issue.
Well, I'd back up a little bit and say, right before we went to see Ed Griffin, we had talked about that. And then I got an email from people involved with the Pro-Family Legislative Network and the Heartland Institute, people from a number of different organizations that had begun working on this and legislation, and then it was just a matter of beginning to cooperate with them. And for me, it was a dream come true. I knew that this was done by subverting local law, both at the national level in Europe, but before that, in all 50 states through the UCC. And I guess I had mentioned that in some interviews, but these people, the people in this group, really, I think independently decided that that was the way to do it, and had begun work on that. And they, through their organizations, I was told they were in touch with 200 legislators in, maybe, I think at that point, maybe 6 states. So it was, it took off very, very fast at that point. And it's amazing to think how much has happened since. Really, most of the attention to this has occurred just since December. A lot of people just became aware of this in December. So it's only been 3 or 4 months.
It's quite remarkable.
So they got in touch, and then we, you and I fit in with the trip then, somehow figuring out how to get from Ed Griffin to Pierre, South Dakota.
It was quite an adventure.
Yeah.
But they forwarded this bill, it got thrown out, but I think it brought the issue to people's attention. And then, the last 2 weeks we've been working on this Tennessee thing. Tennessee-Florida bill that got further. It went through the Senate and the subcommittee in the House. And then in the House full committee, the Civil and Judicial Committee got put for summer review. But a lot went on there. We went and talked to everyone on that committee. And at some point the mood changed. Clearly the bank lobby came in, put their foot down. But I think people really did become more aware of the issue there. And the committee documentation or film, the committee recordings show that.
Yes.
So, there's a lot to unpack there.
We got in, and it was hard to get to Pierre. The weather was bad. We got there. We thought we might have to be there on the Monday morning, but we couldn't get there. And fortunately, the committee hearing was moved until later in the week. And but on the Monday, we were able to meet with legislators Monday night, and there was quite a strong attendance. There were a lot of people that came. We met Julie Auch, who is the sponsor of the bill, who's a very courageous woman, conscientious. She is someone who is in the investment business, who has clients. And when she became aware of this, she became concerned about her responsibility to them, and that they were informed about this, and about the potential liability that people in
that she would take as an advisor.
That she takes as an advisor if they were not informed. And that's what people should be thinking that are in the financial services industry, that they are in the front line when this happens. So they are really being set up as the patsies that will bear the brunt of this. It was when we were there in South Dakota, I woke up in the hotel room and this image came to mind of the medieval castle town. And this was based on Julie Auch talking about this issue. And the image, the issue of the liability for the service providers, in these castle towns, in
the Middle Ages, sir.
In the Middle Ages, they built the town walls, and people were encouraged to move in and live in a village inside the town walls. And they felt that they were being protected by the lord in the castle, when the strategic reason for doing that was that they provided a buffer for anyone attacking the city. They would have to go through the town folk before they would get to the castle keep. And that is the model for this in the financial system, that the financial services industry broadly is the townspeople. And the Federal Reserve and JP Morgan Chase and the Bank for International Settlements and those people are far removed. So the displeasure of the public is going to fall upon the people they can get close to. And that's where the suits are going to come. And
do you think they're just thinking that no one will have the money to fight it in court, and in the meantime all their assets are swept up? And
I think it's intended to happen very quickly. There might be we could be in a global war situation at that point. There will be, they intend to make it very difficult for people to focus and respond.
And some recent articles would indicate that, saying the Russian potential war with Russia of Europe could cause a crisis at Euroclear.
Yes, this is just recent. And it does fit.
Like they're mixing these issues, huh?
Well, that there has been discussion. Well, it's interesting because the discussion about the vulnerability of Euroclear and the central clearing counterparties began some time ago, and well before the invasion of Ukraine. So they were already talking about this before being able to blame Vladimir Putin for the collapse. They were already planning for it. And but now what is being discussed is that with the NATO countries perhaps moving to freeze or confiscate Russian assets at Euroclear, and then Russia retaliating by freezing assets of Western entities in Russian banks, that this will create uncertainty about collateral within Euroclear and precipitate a collapse. So then it's convenient because it's been set up to happen, but then it will be possible to blame it on Russia and an escalating war in Europe.
So let's get the Tennessee stuff done, huh?
Well, let me
Yeah.
let me just.
Okay.
I think what happened in South Dakota, in the hearing, where Julie Auk and Don Grandy were testifying, there was a large presence of witnesses for the banking lobby that were actually given more time than Don Grandy and Julie, and they the main thing they did was to read just the section of the code that says that entitlement holders have priority over the creditors of the intermediary, and stop there. So this is how people are misled. They assert that, and they leave out the exception. And the hearing was run in such a way that Julie Auk and Don Grandy had no opportunity to respond to that testimony. So it's a matter of how the hearings are run, so that the banking lobbyists are able to say things without being refuted.
And there it was moved to the state committee, which a lot of people there told us is where they put bills to die.
Well, I think it was a committee they could run and do a kind of hatchet job. And then that was overridden. They got the votes to force the bill onto the floor. And then there was a different tactic where the two sponsors of the bill were not allowed to speak to the bill at all on the floor. They were when they tried to speak about the bill, they were told to speak to the motion. You know, the decision of whether the bill should be allowed to be heard. It's kind of a strange thing that they could not offer further information.
Even though they were the sponsors.
Even though they were the sponsors, it was very limited, and they were bracketed by people, and this is the way it is done, the people on the floor that were positioned to speak both before and afterwards were able to say, this has been thoroughly examined, we've heard all about this in the committee from the experts, stop wasting the people's time. So that was said both before and after they had a chance to say anything, and they were really prevented from saying anything. So it's done in a procedural way. So that bill was not allowed to be heard on the floor. It was basically silenced. And the only way they could have overcome that, and I think it could be done, it's important to talk about this for future efforts, is for them to, as soon as they were able to say something, to say there were the testimony of the banking lobbyists, and to mention right up front, these are banking lobbyists, was misleading and factually incorrect. And the people of the state deserve to have a hearing of this issue. We were not allowed time to address these factually incorrect statements. To say that before they are silenced at the first stop, because there's going to be a very limited opportunity to speak.
We just spent some time in Tennessee for 2 weeks in a row on this bill that was forwarded by a respected member of the House and well liked. It's basically all Republican. We went there together. You testified on the Civil Justice Subcommittee.
Yeah.
And a couple members asked some really good questions. Like, clearly they had looked into it and it surprised them. And the head of the Black Caucus of Tennessee, he remarked that this was probably the most interesting committee hearing that they've ever had.
Yeah.
Which is a pretty big deal, yeah.
Yeah.
So it's not a partisan issue. This is an issue of property rights and whether we have priority to our own assets and that they not be encumbered, through this dematerialized indirect holding system through DTCC. And anyway, no, it was a really informative experience. Yeah.
Well, Betty Grandy, wife of Don Grandy, had been there 2 weeks before us.
Oh, really?
And apparently had done quite a good job with the committee and working with Bud Halsey, who is the sponsor of the bill. And so when we came, so I was testifying with Don Grandy, and we had a good opportunity to speak, and we were up against Andrew Guggenheim, who is
he's the head of SIFMA?
I think
What's it
he's
called?
a general counsel or associate general counsel for the Securities Industry Financial Markets Association, SIFMA.
Okay, SIFMA.
Yeah.
And that's the same organization that offers an insurance?
No, that's the SIPC.
And what does that stand for?
Securities Investors Protection Association, I
And that's
think.
a private thing?
It is private, yeah.
Okay.
It's not a government entity,
Okay, so multiple times in the hearings,
yeah.
and I think the members were told, we've never had a problem in 2008, which they kept reinflating, right?
Yeah.
So everyone was made whole in the Lehman Brothers case. Everyone was made whole, and we've never had. No one's ever lost out.
There's
right?
never been. No one's ever lost anything. There's never been a problem.
There's never been a problem.
Yeah.
And they always refer to this SIFMA. How do you call it?
No, SIPC.
And that's this. What does that mean again? The
Securities Investors Protection Association. I'm pretty sure.
Okay, that might be interesting to dig into who started that and
Yeah.
which lawyers
I mean,
and what was their
that's
prior
well, that
program?
was started in 1970. So right at the time when they were going to the dematerialization. So it's very important. Let's expose that
Yeah,
because
note to audience, look into that.
because that is used as
As a foil,
a foil. It's basically a con. So what they've done is taken your property rights. There's no coincidence that it was done right at the time they were dematerializing. So they were going to fuzzy up who had the collateral and who was using it. So it was done in 1970, and you have, for example, in the hearing just this week, the fellow saying that under softball questioning that you have $500,000 of protection, and if you're married, your wife has 500, so a married couple would have $1 million of protection. Now, there are a number of problems with this. First of all, that does nothing for institutions.
Right.
Does nothing for your pension funds, your investment funds.
So it just covers individuals.
It's just individuals, and
But individuals usually have it invested through an institution, no? Your 401k, your.
well, no, it would cover your IRA or your own accounts. But the point is, the much bigger funds have no coverage at all. So, you've taken property rights and given an appearance of protection through an insurance scheme. Now, the important thing for people to understand is the total capital in SIPC is just a few $1 billion, just a few $1 billion. So it measured in comparison with the pooled securities at DTCC, which is over $87 trillion, it would be measured in thousandths of a percent.
If the $87 trillion at DTCC is being used,
Yes. The insured portion is
$3 billion.
infinitesimally small. So it is
Not really an insurance fund.
well, it will provide no protection in the failure of even one major institution. Now, the other thing, when they say that there's never been a problem with this, or no one's ever lost anything, so that is not a correct understanding of what happened in the last financial crisis. In the case of Lehman Brothers, and there were other smaller failures. But the important point is that when Lehman Brothers filed bankruptcy, all clients had their accounts locked in the bankruptcy from that point.
And that's the main issue here.
That's what is overlooked.
Yeah, and at no point, if property rights on securities are respected, then at no time should any client's assets become encumbered in the bankruptcy or insolvency of their broker, custodian, or a higher level intermediary.
That would have been the case before the creation of the concept of a securities entitlement, which is a contractual claim. If there were a failure, if your property was not returned, that was criminal. And now it's a contractual claim. So you will be encumbered in the bankruptcy. It's only a question of what your priority is. Do you have priority over the creditors of the intermediaries or not? And the way this is set up, you will not have priority over. That's what we're seeking to change through this, simply by striking the exception that creditors of the intermediary have priority if they have control, or creditors of a clearing corporation have control. You just strike those exceptions, and then entitlement holders have priority. They'll still be encumbered in the bankruptcy, but they will have a actually quite a good chance of recovery. Now, what happened in the case of Lehman, if there had been a continuing financial crisis, there would have been losses. The difference is the bubble was reinflated.
But the court documents, to be clear, did say that the protected class, i.e. J.P. Morgan Chase, that was the custodian and the secured creditor, did have dibs on other people's, on the public's asset.
The retail accounts were all encumbered in the bankruptcy. People lost access to their accounts in the middle of a horrible financial collapse. They eventually recovered control of their accounts when the retail business was sold to another bank. But it took a couple of months for that to happen. It was uncertain whether that would happen.
And the institutional was 5 to 10, 11 years or so.
Well, the institutional accounts, in total, the bankruptcy was not wound up for 13 years. Took 13 years. We know that, now this is the most shocking thing, which is overlooked in the testimony by these bank lobbyists, to say that nothing happened, no one has ever been injured in this. The institutional clients had their collateral free and clear to use in the crisis, on behalf of their clients. And when Lehman filed bankruptcy, their collateral was encumbered in the bankruptcy, and it turned out that J.P. Morgan, which was the custodian for those clients, also then took the client assets as secured creditor. So J.P. Morgan was acting as custodian and took the client assets. And this is what the bankruptcy court was hearing.
Sounds like a conflict of interest, huh?
Well, there used to be fiduciary duty, but now this is legal. As we see, this is what the bankruptcy judgment was about, and it's just shocking because the judge found that Lehman, or that J.P. Morgan was entitled to keep the client assets and did. And this is 5 years later. And in the judgment stated that Lehman, or that J.P. Morgan was entitled to do so as a member of the quote unquote protected class, meaning.
What was the date of that judgment?
That would have been in probably 2012 or
So like 5 years later?
2012 or 2013, somewhere in there.
But at some point after that, they got their assets back, or
They did recover their assets.
after more
They
lawsuits?
did recover. They did recover. You know, there was eventually full payout after, within 13 years. Different parties at different points. But the analogy I give, imagine you're in a terrible financial collapse, which it was, and you need to be able to navigate. Now, the analogy, another car analogy, you step out of your house in the morning to go to work, and your car is gone. And now you can't get to work. And in the example of retail accounts, for 2 months your car is gone. And then after 2 months, the police bring a car by, and it's not your car, it's just another car. Does that mean that your car was not stolen? Because after 2 months, you were given a car back. Or on the other hand, the comparison with SIPC, if your car is stolen, you walk out to go to work and it's gone, and eventually your insurance pays you something, does that mean your car was not stolen? So in both cases, you have lost control of your property. It was taken. We had showing up Andrew Guggenheim and Tim Amos, who's with Andrew Guggenheim with SIFMA, and Tim Amos, who's with the Uniform Law Commission, and they were mainly asserting that this proposed striking of the ability of secured creditors of intermediaries to have priority to client assets, that would prevent people from having margin accounts in the state and would require changing contracts because of the change in place of law. But let's mainly look at this. First, look at this issue of the margin. It's a misdirection. A margin account is an agreement between the investor and the broker. It is really a retail account. It's
unrelated to the language of
it is
the Article 8 amendment.
Completely unrelated to the major concern here. And you can just see in the code itself that it relates to priority of the creditors, the creditor, or of the
intermediary.
of the intermediary, not of the entitlement holder. So a margin account would be a creditor of the entitlement holder. So they're completely different issues. And they completely ignored the issue of the using of collateral from these pools at a higher level.
Yeah.
Now, it was eventually acknowledged under questioning of Andrew Guggenheim by Antonio Parkinson. He did a great job, and ultimately, I don't know that many people really focused on it or noticed, but Andrew Guggenheim acknowledged that there are securities being used from the pool.
He certainly did. I mean, he kept asking him that, like, so are they?
He pretty much had to drag it out of him.
Yeah.
And, but that seemed to be forgotten, that happened. The really significant thing there was that Antonio Parkinson is the chairman of the Black Caucus and a Democrat, and he was in support of this. And the following day, there was a vote in the Senate committee, and that was approved unanimously, support for this bill. And the Senate majority leader, Republican, voted in favor of this. So you have you have a Republican majority leader and the chairman of the Black Caucus, Democrat, both supporting this. So that is hugely positive, and Betty Grandy said that has national implications, and it will be recognized in other states. So it's a people issue, not a partisan issue, and people are beginning to realize that to the extent it's partisan, it's really people versus the banking interests. That is coming into focus finally.
Yeah, and that's what's so beautiful about this issue, is that it's not partisan, it's not political, it's all of our property, all of our assets at stake, and we need to start taking this seriously.
Yes.
Yeah.
Well, it's vital because the banking interests we can see it. They are joined at the hip with the escalating war, global war, and if you go back through the history of the last century, the banking powers are always joined at the hip with warfare and with centralized power and totalitarianism. They're not capitalists.
No, absolutely not. So how would you summarize what happened in Tennessee then?
Well, I think things were going very well after the first House subcommittee hearing, the Senate hearing the next day. There was very, very positive energy. Clearly this nonpartisan support, and we felt it was there was such a real possibility that this could be passed, that it was important to stay here and see it through. So we stayed into the next week, and we worked for 2 days going around to all the representatives. And I'd say the first day, there was the very good energy continued on the Monday. On the Tuesday, something had changed. And we started getting mention of the state, the treasurer for the state, that the treasurer wanted this to go to summer study. So not to be passed, to go to summer study. We were told that summer study can be a way of sending a bill to its death.
Yeah. We were told 90% of the time that's the case.
Yes. And there were some strange things about it in that in our first two meetings with representatives, they mentioned that the treasurer was coming with the banking lobby to see Bud Halsey, the sponsor of the bill, and then we went to his office and he was unaware of that. So there were other representatives that were aware that the banking lobby and the treasurer were going to, blindside Bud Halsey. So we then went to that meeting. And it was I felt oddly a hopeful meeting because we were all able to sit down together. We had the two banking lobbyists on a love seat next to us, and the treasurer and his chief of staff there, and Don Grandy and James and myself and Bud Halsey. And I mean, that's really amazing to get all of those people in one room. And we seemed to have a genuine, open dialogue. The treasurer acknowledged both he and his chief of staff were reading The Great Taking at that time. Mm-hmm. So they were, I still felt that there was a hope that we could make this work. That there would be enough votes. And then when we got to the hearing the next morning on Wednesday, the word came down that it was the Speaker of the House had directed the chairman of the committee that this was to go to summer study. Yeah. And that was the decision, and it didn't matter what would occur in the committee. That was going to be the decision. So again, it's done on a procedural basis. Mm-hmm. I'd say the unfortunate thing that happened was that initially we were told there would be no testimony, and then the banking lobbyists were given basically a half an hour to really say things that are untrue. And we're going to have to spend some time unpacking those things and addressing them. I've already done a rebuttal letter to Andrew Guggenheim's letter from SIFMA, which was shared with the committee, a rebuttal letter to their testimony last week. I'll be doing another one to this testimony. So they were given half an hour, and then Don Grandy and I were given a total of 3 minutes, which maybe I didn't maximize so well, but I tried to get something in there to make it clear that this is real, and that there is real primary source documents making clear that this is real, and also directing the representatives back to the documentation that they had been sent, the refutations they had been sent, because we wouldn't have time to talk about it. Yeah. But maybe we could go into some of the things that were said by the lobbyists. Of course, again, they talked about claiming that this would make it impossible to have a margin account.
We've gone through that already.
Yeah, which has nothing to do with. Then there was this statement that the securities intermediary is not permitted to use a customer's security as collateral for its own debts. That would be a criminal act, which is just manifestly wrong, because it is being done
It's being done already.
On a
yeah.
big scale. So
Yeah.
that's just an outright false statement. Well, let's talk about a couple of issues here. Representative Bolso pointed out this section 8-504B. So this is in Article 8. Except to the extent that the securities intermediary and the entitlement holder otherwise agree, a securities intermediary may not grant any security interest in a financial asset. So he read that and stopped there. He did go on to say that what this bill is addressing or speaking to is that somehow entitlements are being created or exposure is being created. A security interest is being created to the detriment of the entitlement holders. So how is that happening? And so he asked that as a question, and the banking lobbyist basically said there's no evidence that that's happening.
Which isn't really answering the question.
It isn't answering the question. He just says there's no evidence that that's happening. James actually found this while we were talking about this. We were thinking that there must be an exception to this, that they like the what was done in South Dakota. They're just reading part of it and then stopping. So they're reading the part which seems to assure that it can't be used without an express agreement and just stopping there. But sure enough, at the bottom of this section, 8504D, it says, this section does not apply to a clearing corporation.
Which is DTCC.
Which would be DTCC. Other entities can be clearing corporations, but DTCC clearly is. It goes on to say, this section does not apply to a clearing corporation that is itself the obligor of an option or similar obligation. Think a derivative contract.
It's obliging people to the assets.
Counterparty is the obligor of the in the derivative contract. So it says, this section does not apply to a clearing corporation that is itself the obligor of an option or similar obligation to which its entitlement holders have security entitlements. Now that's a little unclear, the last part of it, but the entitlement holders are essentially encumbered in DTCC. All of the entitlements are held there, and DTCC is through the central clearing counterparties there is extending the client assets from these pools under these derivative contracts. It's the margin that is being posted, as well as what will be posted in the mutualization of losses through the collateral fund. So this again is the key line. This section does not apply to a clearing corporation. The other really big thing that was happening here, although people may not have realized it, is that they were being threatened up, down, and sideways. They were being told that if this change is made, financial firms will not do business within the state of Tennessee, and in fact, they will not do business with any firms that do business in the state of Tennessee. Yeah. So that Tennessee would become a complete pariah. And then the bank lobbyist went on to say that this would undermine the assurance that the centralized intermediaries will have in their rights vis-a-vis the Tennessee intermediary. So that...
Implying there's some agreement between, let's say, a local custodian and DTCC. There's some operating agreements there.
The control of the property.
Yeah.
That it is about that if you give priority back to the investor, that it affects the centralized intermediaries. And then he went on to mention DTCC specifically, and that this would be bad for DTCC. So if it's really about margin accounts and there's no problem here, why would giving priority back to investors affect DTCC unless they were using the collateral?
Yeah, why mention them, huh?
And also to say it's all about protecting DTCC, which...
Yeah, he did say that.
Yes.
Yeah, it was a very telling hearing. I mean, it was one-sided. It looked like the hammer came down, the influence came down. The chairman of it even mentioned that. He said he was surprised by the attention this was given.
Yes.
The exertion of some influence or
Yes.
of attention from above. And yeah, it was quite telling. I think even though it wasn't a success, it was a little,
Well, there were five. I think this time there were 4 bank lobbyists that were there.
Well, the other guy was there too. There was 5, yeah.
5 bank lobbyists.
Yeah.
And in the first hearing, they sent Andrew Guggenheim, a member of the Guggenheim family. So it received quite serious attention.
Yeah, certainly did. What do you think was learned from that? Huh?
Well, I think people sensed that this was over target. It was over the target. And it I think was significant that both the House Majority Leader, who was on the committee, and Antonio Parkinson, the chairman of the Black Caucus, Democrat, made the same observation.
Yeah, they both alluded to that.
They both alluded to that, that there's something here.
I thought it was very informative. It was educational to go around to 20 people's offices and talk to them about this complicated issue and try to get the message across in 10, 15 minutes at most, sometimes 5 minutes. And yeah, we definitely noticed a big shift in the attitude on day 3.
Yes.
And it looked like kind of the fix was in at that point. And
yes. But it's not going to go away, and they know that. And I do have to say I was very impressed with the people there, despite the way it ended on Wednesday. But the whole experience of the openness of people to discuss this. Yeah. I mean, there was a lot of kindness and openness, and I think strength in people to stand up here. I think it's very promising.
Yeah, it was really nice going around to these offices and being able to talk with the members.
Yes.
And
the openness, the access, the openness, the willing to talk, the willing to hear about it. And I think people have the right intentions. And I do understand that this is pretty mind-blowing to people, and they have a big responsibility, and it is understandable that they need some time to adjust.
it took me a few months to get my head around it, and
Yeah.
it's a huge issue, and we definitely had a good impression of the members of Tennessee legislature, and
Yeah.
it was quite an informative, experience. We
Yeah.
hope it gets out of this
Yeah.
summer session,
And I think seeing, the exposition of the arguments from the banking lobby, very important, to have all that out. And their points it takes a little bit of work just because there's so much there to address. They don't stop, but their arguments are easily shown to be grossly misleading and factually incorrect across the board.
Yeah, so going forward, we're going to put the original documents there, make some informative films.
Yeah.
I think it's important to look to the original source documents
Yeah.
and primary sources and make a clear exposition of the facts, because there's enough information and documents from the Federal Reserve, from the author of the 90s amendment of the Section 8 UCC, from BIS and other sources that this is a real issue. Clients' assets are being used.
Yes.
And it's definitely not an industry. It's not an industry practice that should be happening.
Well, and it's clear, the bankers, the banking lobby, they are the last people that are going to explain that they are doing this and how they're doing. They do not want you to know, and they do not want this to be reversed. So they are not the people that are going to tell you about it.
Yeah.
It's understandable that they're going to come down full force on this to keep it from being reversed, but ultimately there will be more people that know about it, see it clearly, because it's irrefutable.
Yeah.
And it's not going to stop. It's not going to go away.
Definitely heard the bank lobbyists kind of innuendo a threat a few times that, they might deny service to the state if they did that.
Yeah.
So I think it's important that the whole country approach this issue, lobby the state legislatures, get the 90s amendment adjusted back to the way it was before, and then we all look at this, together and get it done, and don't allow the banking lobby to try to punish a state that does it first. And
it's going to be very important to face them down, the banking lobby, because they are fear-mongering and outright threatening the state of Tennessee when they do this.
even if the legislators maybe have not noticed that, that's what they were doing.
People have to realize they're being threatened, to make that present in their own minds and to speak about it explicitly.
Well, thank you, David.
Thank you, James. It's been
a little roller coaster ride.
Yeah, it's been a roller coaster ride.
Yeah.
But I would do it all over again. Thank you.
What's the value of life if you don't fight for it, right?
Yes. It's been quite a big experience.